All right. Very pleasant good afternoon, everybody. I've been rehearsing that in my head so many times because I'm used to saying good morning for these webinars, but good afternoon. This is a co-produced webinar for the 2025 legal update for CAM CE credit. If you're a board member, please stay, hang out, and watch. But this one is good for CAM credit. We're going to get started in just a moment. So I'd like to introduce Lisa Rosenthal from ACE, which stands for Association Community Education, but she's also an ace at what she does.
That's very kind of you, Jeff. Thank you so much for that lovely introduction. Emily, thank you so much for this presentation you're about to give. I love working with Emily. I have the pleasure on multiple occasions, and she's fantastic at what she does. So thank you for being here. So folks, acebytsk.com. That's where you'll be able to register for March 6th. March 6th, ACE is presenting a very unique program, which I think is different than most of the programs that are presented. Oh, thank you, Jeff. So Jeff just put it up on the screen. He's showing you what we're up to. So we have a program throughout the course of the day on March 6th. You don't have to sit for 7 hours, but we've got some really great programming.
Well, we want you to, but you don't have to.
Yeah, listen, and we have some, so in between these great programs that start at 8 a.m., in between them, we have some overtime content for you. So there's commentary, and Jeff and some of our significant professionals that will be speaking and presenting have kind of a sidebar in between some of that. So that'll be a lot of fun. But we would love to have you go to ACE by TSK, take a look at our programs, register, and you'll get a lot of notification between now and then reminding you. But yeah, we're really excited about March 6th. It's the first time we've done a program like this, and we're looking forward to seeing all of you.
Thank you, Lisa. And we'll talk more about that later, including Kay Bender-Redbaum's involvement. What I'd like to do now, because there is a lot of material to cover, a lot of slides today, I want to introduce one of our esteemed attorneys from the Kay Bender-Redbaum office in Pompano Beach, Florida, the main office. This is Emily Gannon.
Oh,
it's all yours.
Hi, guys. All right. Well, let's go to our little page here. First, let's start there. All right.
And we can see it. Yeah, that's good.
Okay. All right, guys. Well, hi, everybody. My name's Emily Gannon. I'm one of the attorneys here at Kay Bender-Redbaum. We work with ACE all the time. They're great. You guys, I know, get a lot of education from them. As Lisa said, I love working with her, so we're a little spoiled here. The focus of our entire association, or of our entire firm here, is association work. It's all we do, community association work. So it's basically, essentially, we represent the associations, sometimes developers or individual owners, but for the most part, we're representing the associations, the condos, the HOAs, the co-ops. And a big part of what we do, we like to do these educational seminars so that all of our board members and the managers we work with get the education. That makes our lives a little bit easier. And also, realistically, you guys have to get the education, so we want to be the ones to give it to you, make sure we're all on the same page. So if you need anything association-wise, you can contact us. All of our information is there. We'll dive in. Like Jeff said, today is meant to be educational only, no legal advice. You're going to hear my opinions occasionally sprinkled in while I'm doing this. I like to try and keep it interesting for you guys a little bit. You are going to get copies of the slides. There are a lot of slides. There's a lot of information here. I am not going to just read every word off of every slide because you would probably be bored to death and fall asleep. I'm going to hit the high points, and some of the stuff we may sort of skim through, but you'll have the information. You can take it with you. You can go through it, highlight, do whatever you want to do. All right, so let's dive in. And it is 2 hours. So I'm going to go through it, and then we can wait and hold questions till the end. It is the 2025 legal update. Okay, so we're going to cover a lot of stuff because it sort of goes, it runs the gamut. We talk about some changes to 718, to 720, to some other statutes as well. So we cover a lot. So because of that, you may have questions about a million different topics, but we're Probably not gonna be able to get to them. We got to sort of stay on track here. So let's dive in. First things first, like I said, I already introduced us. This is another page about what we do. Please come to our website if you have questions. We publish lots of educational materials there for you too for free. First section here is really about CAMs, management companies, community association managers, and the management companies. Most of you guys, this is for CAM credit. I assume a lot of our audience are probably CAMs. So this is where you guys need to really pay attention, all right? Because this is the part that applies to you. Hopefully you know about some of these changes already. So now, House Bill 1203 dealt with changes to Chapter 468 of Florida statutes. That's the chapter that deals with CAMs and management companies. CAMs are community association managers. They have to be licensed. There's some regulations in place. If you're board members, hopefully, you know, that may not be so familiar to you. That may be a little foreign. But the CAMs are the people right now that need to pay attention the most to this part. So if you're a LCAM or a licensed community association manager, you have to attend at least one member meeting or board meeting of the association annually. New requirement. This is really only applying to HOAs. For whatever reason, that's where we are with it, but keep in mind, that's your new requirement. Also for HOAs, if you're a CAM for an HOA, you have to provide the members, all of the owners, essentially certain information that has to be on there. You know, it has to be so that the owners can basically contact you. So they need to know who the manager is, who the assigned person is, how to contact them, the contact information, things like that. They want the owners to be able to, again, get in touch with management. This makes sense. Okay. That information has to be posted on the website or the association's, you know, app or portal or whatever we want to call it, whatever that online information gathering site is. If it's a website, if it's a portal, you can also do it through an app, but same thing, okay? When I'm saying website, it also applies. It could be an app, essentially. You could have it, you know, downloaded on your phone. The association manager has to update the association and all of its owners within 14 business days if any of that information changes. So keep that in mind. If you're a management company or if you're a manager and you're newly assigned to a community, odds are the owners have the old information. You need to make sure it's updated. Keep everyone posted on who the manager is. And again, the contact information, how they can get to them, how they can reach them, all of that. The CAM also has to provide a copy of the contract, the management contract, if somebody requests it. That would also be part of the official record. So that would be something an owner would have access to ultimately. But keep in mind, now it's also something specifically addressed in the statute that pertains to the CAMs. And again, this is all only HOA right now. New education requirements for CAMs. The DBPR can require not more than 10 hours of continuing education annually. Biannually, each LCAM has to do at least 5 hours of continuing education that pertains to HOAs. 3 hours have to do with record keeping. And again, this is all HOA related right now. To return records, this was a big one. This was a new section that was added. There was already some language in there, but now we're sort of tightening up. Basically, any CAMs or management companies have to return any association records that they may have within 20 business days after the termination of the contract or receipt of a written request for return of the records. So 20 business days now to give all the records back. If you don't, there's a penalty. So keep in mind, if you fail to return these, it's a rebuttable presumption that you failed to comply, and then there's a penalty. So potentially you could get your license suspended. That's obviously a big deal. We don't want that to happen. Or a civil penalty of $1,000 per day, up to 10 business days, starts to run on that 21st day. There is a little bit of an exception. You get an extension of time if you need the records to complete a financial report or something like that. But keep that in mind. Because again, you guys don't want those penalties and you don't want your license to be suspended. All right. Some financial disclosures. A lot of what you're going to see today, and I guess I should give you guys a little bit of context here. Yes, right now we're talking about CAMs, But overall, some context for some of these changes that we're going to see in this legislative update throughout the next hour and 50 minutes or so. A lot of these changes come from wanting to make sure there's transparency, basically across the board, that there's no inappropriate behavior happening with your management companies, with the boards, things like that. A lot of this comes from what's been in the news the last couple of years in terms of boards, I should say it this way, some bad actors on boards, let's put it that way. You've probably seen some of the headlines. There was a huge case down in Miami. I don't have any confirmation of what happened, but I know that there were actual arrests. And so the allegations are that there were board members that I think they were self-managed, because again, I'm not sure if management company, I'm not sure what the involvement was there, or if there was a CAM involved or what it was, but essentially there was a lot of wrongdoing. They were embezzling funds, there was theft, there was a lot of self-dealing, there was a lot of paying vendors that didn't necessarily exist, or allegedly paying contractors that were family members of these board members, various allegations. Again, this is all in the news. It was a big arrest, big bust, big story that you know took up lots of airtime, and there were arrests. Owners were trying to figure out what was going on in their community. Where was their money going? Why was there no election? All of these things that were happening. And so again, we really want to make sure nothing like that happens again, and that everybody is being transparent. Everybody is doing what they're supposed to be doing. And you'll see sort of that trend in a lot of these changes. So that being said, this is one of those where you can kind of see where that tone is in the legislation here, where CAMs, and that's directors, officers, persons with any financial interest in a management firm or a relative of such person, they have to now disclose to the board any activity that could be reasonably construed to be a conflict of interest, because we want to be very careful about any of these allegations of self-dealing. So we're very concerned about possible conflicts of interest. This all tracks. There's a rebuttable presumption of a conflict of interest if any of the following occurs and there hasn't been proper notice, or prior notice, I guess I should say. If there's a financial interest from the CAM, or again, you know, whoever it may be, an interest in the management company, and they enter into a contract for goods or services with the association, a relative of that person. So again, either the management company has an interest in another entity that then the association is going to hire, or maybe individually, your individual CAM perhaps is maybe married to a gentleman who owns the best landscaping company in Broward County, or the association's considering hiring, you know, their adult son as the maintenance guy. So it doesn't necessarily mean there's anything wrong, but we just want to make sure these disclosures are done properly so we don't run into a problem with a conflict of interest. If any CAM, again, or person in a management company that has a financial interest receives compensation or any form of anything of value, essentially, from a business that conducts business with the association, that's a potential conflict of interest there too. So again, it doesn't mean you can't do it. It just means we have to have certain disclosures in place in order to do it properly without issue. Bids from your CAM. This is also important. If you get a bid, if the association gets a bid from a CAM that exceeds $2,500, and that's from the CAM, including, again, any relative of that person, financial interest, all of that, you have to solicit multiple bids from third-party providers. That, again, all makes sense. If a CAM or any person with a financial interest, is engaged in any activity that is a conflict of interest, that proposed activity has to be listed on all the contracts, and documents related to that proposed activity must be attached to the meeting agenda at the next board meeting. That disclosure, like I said, it doesn't mean you can't do it. It just means you have to take extra steps. You have to disclose this information, and ultimately then there's going to be a board vote, and that board vote is a little different. It's not the normal majority. It's going to be 2/3, and potentially at your next meeting of your membership, that information also needs to be disclosed to your owners. So a lot of extra steps, but again, it's to make sure that everything's on the up and up and everything's disclosed. All right. If you don't disclose these things, then the association can actually, one of the possible penalties or remedies, or however we want to look at it, the association may be able to cancel its management contract. And then the only penalty, they're not going to have to pay any termination fees or liquidated damages or any of that. They would just have to pay the actual value of the management services that have been provided. And additionally, you can be penalized, or you can be, there can be penalties imposed by the DBPR. And that's who regulates the CAM licenses and all of that. So there can be disciplinary proceedings there. So keep in mind, we want to make sure everything's on the up and up. Doesn't mean you can't do it. Doesn't mean that, innately there is an actual conflict and there is something improper happening. It just means we need to disclose it because there could be a conflict. And as long as we follow the right procedures, we can still proceed. If the association enters into a contract with a CAM and there's an activity that is a possible conflict of interest and it wasn't properly disclosed, that contract is voidable and terminates if the association files a written notice, basically terminating that contract. It would take 20% of the voting interest to approve that, but just so you know, that's another possible penalty. So you can potentially terminate the management contract and potentially terminate the other, whatever the actual contract is. All right. Some technical things in this bill. They just clarified that notice of cancellation would have to be certified mail, return receipt, unless the contract requires something else. And whenever we say relative who has a financial interest, relative is sort of a loose term. They did define it specifically. It means a relative within the 3rd degree of consanguinity by blood or marriage. So it doesn't mean your, 12th cousin down the line. All right. Senate Bill 382, the DBPR shall exempt an individual from completing the continuing education requirements for renewal of a license for a renewal period if the individual holds an active license issued by the board or department to practice the profession. The individual has to have continuously held the license for 10 years or no disciplinary action is imposed on the individual's license. Then they don't have to take those extra steps. This doesn't apply to engineers, CPAs, brokers, certain designers, all of that. Essentially, this took effect July 1st, but it expires in 1 year. So basically the exemption is only going to last another year unless they change that. All right. Now let's get into official records, website requirements, all that good stuff. Now, if you're a board member, these next sections should probably interest you a little bit more, but we'll dive in. All right. First, we're talking about House Bill 1021. This is Chapter 718. So when we say Chapter 718, you should know we're talking about condos. We're in condo world right now. Now, you already know, hopefully, a lot about official records. It's been something that, is a topic every year, and it seems they tweak the statute every year, but we have some new stuff in here and new things to be aware of. You have 1 year, essentially, January 1st of 2026. Now you need to have a website or an app. Again, like I said, website could be done through an app too. If you are managing a condominium of 25 or more units. It used to be, and it still is, 150 or more units requires a website. Now you have 1 more year, January 1st of 2026, if you're 25 or more units. So we increased the requirements in terms of applying it to more condominiums. The theory is it's supposed to be helpful to have all of these documents on a website, make it a little bit easier for the owners, easier for everybody to get the documents. They're telling us now, in advance. So hopefully you have some time. If you don't have a website already, if you figured, well, we're only 100 units, so we didn't have to because we only had, the requirement was 150. Well, now it's going to apply to you. It's 25 or more is now the cutoff. So you have a year. Oh, yes, Jeff.
Hey, I want to reiterate, this is when I typically cut you off when you talk about this stuff, because this inevitably will come up in the Q&A about 1,700 times here. A portal and a website typically are synonymous. When people refer to a portal, all that really means is a section where you enter a username and a password to get into a private side of something, i.e. a website or an app. So if you hear people saying, we have a portal, not a website, is that good enough? Well, you ask some questions, because usually that's the same thing. The bottom line is, and Emily, correct me if I'm wrong, it just has to be something that has an owner side that
Yes.
the general public cannot see for the sensitive documents and records and all that good stuff.
Right.
Okay.
To comply, it's going to have certain requirements in place, and we're going to get into a couple of them. So, all right. So 25 or more, you have about a year to sort of get your ducks in a row and get this going if you don't have a website or a portal or whatever we're calling it, some online location where you can view documents, basically. Another new change, or not change, I guess, some clarification. There were always questions about email addresses. Still comes up, still a question. You know, you may have email addresses in your records of your owners. Obviously, just because of how, you know, business is done now, people email, they send emails all the time. They probably email the manager, hey, I had a question, you know, XYZ. That doesn't mean that that email address is now just part of the official records to be disclosed to others just because the manager now has them or the board now has that person's email address. Email addresses, to be clear, email addresses are only going to be open for inspection, only accessible to other unit owners potentially, if that owner has consented to receive their official notices by electronic transmission, or they have actually indicated and essentially consented to the disclosure of their email address. And sometimes people do, if you know, set up a whatever it is, you know, email blast list or email whatever sort of directory for your building. Maybe people don't care. They've shared it. They're okay. They've consented to sharing it. Great. We typically hear it from the other side where people say, I don't want to start getting email blasts from everyone in the building who's complaining about, you know, whatever, management or the board or their neighbor or whatever it is. I don't want my email address out there. How do I make sure it's not out there? It's part of the official records potentially if you've communicated with it, but it's not going to be open for inspection unless you've as an owner, you consented to receive electronic notices or you've consented to provide your email address. So there's some clarification in the statute on that, which was nice to get. Official records also now includes invoices, receipts. They've specified these things now, deposit slips, anything that really sort of explains an expenditure. Makes sense. Copy of building permits and educational certificates, that should all be in there too. Now, here's something to really keep in mind, because this is new and this is something you guys, it might change sort of how you're doing business. Let's say it that way. The manner in which you maintain your official records. Now it matters. It didn't necessarily matter before. You were required to keep your records. Great. I mean, if you're not the neatest, most organized people in the world and you just had boxes of records, but you kept them. So we were maintaining them. We had them. They're here. We have all these records. They're all in these filing cabinets. They're all in these boxes, shoved in a closet or shoved in a storage room. And maybe that was fine and well and good back, you know, before now. But now, new requirement, the official records must be maintained in an organized manner that facilitates inspection of the records by a unit owner. So, and even more so, in the event that any of these records are lost or destroyed or otherwise unavailable, the association is supposed to make a good faith effort to find them, to recover them as much as reasonably possible. So, you know, the old story of, well, I don't know, we had a board member, he kept a lot of the records in his unit and then he moved away and I don't know, we lost all of, you know, 2019 as a blur. We don't have any of the records. We don't have any minutes. We don't have anything. Well, now you're obligated. You were supposed to be keeping them anyway, but now you're really obligated to try and recover them, restore them. Can you reach out to that guy? Does anyone know where that man moved? Can you get him to ship you the records? You know, all of these things you might have to look into now. And keeping them organized, that makes a big difference too. Again, if you were, you know, shoving stuff in boxes in a storage room, well, now hopefully maybe your boxes are in order. Maybe they're in, you know, some sort of semblance of, oh, this is where we keep all of our minutes. Okay, this is where we keep all of our whatever else, board certificates, whatever. It's supposed to be in a manner that now facilitates inspection. So again, It really shouldn't just be a haphazard, here are all our records. Again, that's a big change, and it shouldn't sound like a big deal if you've been a very organized, team all along, but it could be a big deal if you haven't. So the other part of this now, and this was a help that they added into the statute here, if you get a records request and the records that you have are posted on the association's website, again, or on an app that they can download somehow, essentially now you've fulfilled your obligation if you can just provide access to that website. So if you can just tell that unit owner, hey, we don't have to make an appointment for you to come in and see all of the minutes from every meeting in 2024, because we have the minutes online. You can go to our website, no problem. And now you've fulfilled your obligation. That counts, basically. And again, that could be a website or an app or a portal. Those words should all essentially mean the same thing as long as they have everything they're supposed to have. Another big change when we're talking about official records inspections, in addition to keeping all your records, in an organized manner, you have to have a checklist. This is another step that, it just adds another obligation onto the association and another thing that the board has to be worried about and that management has to be worried about, but here we are. The association has to simultaneously provide that owner with a checklist of all of the records they made available for the inspection and for copying. That checklist also has to identify any documents or records that weren't made available. Now, and you have to hold on to it. So you have to give them a copy. You have to keep a copy. You have to keep a copy of that checklist for 7 years. And it creates, essentially, if you've done the checklist, it creates a rebuttable presumption that you complied with the official records request. I would suggest, again, we're not giving legal advice here today, but I would suggest you talk to your attorneys and make sure you actually have maybe some sort of form checklist that the attorney has looked at, prepared for you, so you know kind of what you're working with here, because for any official records inspection, now that's an additional step that you have to think about. The other part of that is, people always ask, well, how do we know what records we're not making available? Because we assume we're making all of the records available. Well, and I understand that, and that part is a little tricky, and honestly, I don't have a great answer for you, but ultimately, there might be something that you don't have for whatever reason. We know we don't have a copy of the financial audit from 2023 because we're backed up and we haven't done it yet. Okay, so you're going to know that's not there. Or we know we don't have all the minutes from the 2019 year because, Bob moved away and took all of the minutes with him. Okay, you already know you don't have them. Or, whatever it was, there was a fire in the clubhouse. We lost all the minutes from 2019. If you don't have something listed in there, that's really the only guidance I can give you. Talk to your attorneys though, and make sure you're complying with this new checklist section. And here's why. Failure to produce official records, misdemeanor. Okay, this is where I'm going to pepper in my opinion a little bit here, guys. I don't love this. I don't love that they put this in here, but it is something you definitely need to be aware of. Now, there is a possible criminal penalty. I don't know where this is going to go. I don't know if it will ever actually be prosecuted, but a director or a member of the board or the manager who knowingly, willfully, and repeatedly fails to provide such official records commits a misdemeanor of the 2nd degree. Now, repeatedly is defined. It means 2 or more violations within a 12-month period. Again, I don't love it because typically when we're talking about crimes, there should be some level of intent here. There's no intent worked in here. It's essentially knowingly, willfully, repeatedly, but repeatedly means 2 or more violations. What do we really mean by willfully? What if it was a management oversight and it's not the board member that did it? Or, all of these possible variations of how this could go down. But be aware, because now again, you want to make sure you are addressing an official records request timely and immediately speak to your management team, speak to your attorneys if you have to, make sure you are responding so this is not something you have to worry about. Failing to produce official records, felony edition. If a person willfully, knowingly fails or refuses to release official records with the intent to avoid or escape detection, arrest, trial, or punishment, then it's a felony of the 3rd degree. Accounting records, any person who knowingly or intentionally defaces or destroys accounting records. again, with the intent of causing harm to the association, commits a misdemeanor of the first degree. Those two criminal penalties, again, my personal opinion, my personal 2 cents here, I'm okay with, because you're doing, you're wrongfully doing something intentionally to damage the association or to, again, hide a crime, essentially. Now, I understand why these were put in there. Like I said before, when I gave you sort of the layout of the land in terms of the context for a lot of these changes, when we did have an issue with an association that had a board that was not doing what they were supposed to be doing, obviously official records, I'm sure, were not being provided properly to the owners, were being destroyed, were being hidden, were, accounting records were being modified, and that was all to, again, cover up crime. So we don't want that. We want records to be preserved. We don't want, we don't want anybody to cover up a crime. So I'm okay with the cover up being part of a crime too. That's fine. The other one, like I said, is a little different. So, but we've expanded it, and I don't get to make the rules. So be aware that that's there. All right, switching gears a little bit. Now we're House Bill 1203. This is Chapter 720. So we're in HOA world now, but we are going to talk about some of the same kind of concepts. Official records, we're back to official records. Association has to maintain the following for at least 7 years, unless there's something else that says they have to keep them longer. Basically, official records, copies of any plans, permits, warranties, any of that, copies of the official document or the governing documents, so bylaws, articles, deck, any rules, any minutes of the meetings, you have to keep them. Current roster and all insurance policies, you need copies of that. Copies of contracts to which the association is a party, that all needs to be held on to and kept in your official records. Bids received, we get this question a lot. Do we have to hold on to bids, and for how long? Bids received per work to be performed, you only have to hold on to them for 1 year. So at least that cuts down on your records a little bit. Accounting records, tax returns, all of that, all of your lovely list right there. Ballots, sign-in sheets, voting proxies, anything that has to do with voting, really. Again, that's another exception. You only have to hold on to that for 1 year from the date of the meeting or the time of the vote, basically. And then the catch-all at the end is all written records not specifically included in this subsection, which are related to the operation of this association. That's written records, keep in mind. Now, HOA websites, let's talk about those a little bit. If you're an HOA with 100 or more parcels, you need a website. Association's website or app or portal, whatever term we are using for that, has to be accessible through the internet. And this is what we were saying, it has to have a subpage or a portal that other, general public can't get to, because you only really want to keep certain things available for your owners. Parcel owners really should be given usernames and passwords if they request it. I would say assign them, send them out anyway, because that's who can access your official records. The association, there is information, like I said, that's going to be protected. That can't be open to everybody. Association has to be careful about protecting that and making sure those things are safeguarded. Not going to be responsible if some information does get out, not intentionally. The protected information, when we talk about your official records, is anything that's covered by attorney-client privilege. That should not be open for inspection. So that should not be something that would be available to your owners on their website. Any information that's obtained in connection with the approval of a lease or a sale or another transfer. Now think about that. That makes sense. We're doing, possibly depending on your community, you're doing background checks, you're doing credit checks, criminal history checks. You have social security numbers, you have private information, you have sensitive information. That should not be information that's just open to anybody. That's to be kept in the official records, but not open to the owners. So it's official records, but not accessible to the owners. That's what we're talking about here. This is the information that has to be protected, cannot just be, visible on your website. Any information, and this was something they changed a couple years ago, information that the association obtains in a gated community in connection with guest visits. They don't want people to be nosy and be able to track who's coming to see who and whose guests are who and all of that, fine. Medical records, you might be saying, why in the world would we have any medical records of anybody? If you're an HOA, possibly you've had an issue with an owner who needed a reasonable accommodation, a reasonable modification. Maybe they have an emotional support animal. Maybe they needed to switch a parking space because they need better access. So maybe you have an issue where they gave you medical records or they gave you a note from a doctor or whatever it is. That information has to be kept, kept secret, basically. Not open for inspection. You have to keep it, but it has to be redacted, cannot be available on the website, cannot be open for other owners to see. And then the other category makes sense. It's all the sensitive information, the personal identifying information, social security numbers, driver's license numbers, credit card numbers, all of that. You may have those things again to register for your gate or to register for your, online access. If you're a 55 and over community, you may have copies of everybody's driver's licenses to make sure you're complying with your, your age requirements. All well and good, but just make sure that is protected info and it's not out for general, public. So now if you're an HOA with 100 or more parcels, we've already passed the deadline. It was what, 3 weeks ago, January 1st of 2025. You are supposed to have a website that posts all of these things, that has all of this information, that has all these documents. Hopefully you've already done that. Again, website or an app that you can download, whatever it is. It's supposed to have your governing documents, articles, bylaws, deck. And then there's sort of an interesting list of things. It's not exactly in sync with what you have to have as your official records, but it's select items of your official records that need to be on the website. Specifically, what's interesting here is it says a list of your current contracts. A list of your contracts, as opposed to every single copy of every single contract. Your budget, any proposed budget, financial reports, monthly income statements, all of that should be on your website. Insurance policies. Now, this is another interesting sort of distinction here. Any contract that has to do with any potential conflict of interest, that's one of the items. And any contract that has to do with, that's between the association and any director or homeowner or entity where that director has a financial interest. So again, you'll see again this pattern. We're worried about making sure any conflicts of interest are being, out on the table. We're being transparent. We can keep an eye on these things. We want to avoid similar situations to what we've seen in the news. All right. Another new requirement you guys should be aware of, new website posting requirements now for member meetings. Notice of any meeting of the members and the agenda for the meeting 14 days before needs to be on the website. And they want to make it, again, very obvious, open, and transparent as we can be. You can't keep it sort of hidden on the website of, I don't know where I go, I don't know where to find it, this tab, that tab, blah, 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 blah. It has to be in plain view on that home page, or it has to be very noticeably marked, notices. So keep in mind when you're doing your website, make sure you do it where it's nice and open and obvious here. Any document that's going to be considered and voted on by the members during that meeting, or that's listed on the agenda, has to be posted to the website at least 7 days before the meeting that it's going to be considered. So a 14-day notice, if we're doing, a membership meeting, that notice needs to be on the website. If you have any documents that are part of that, anything that's being considered by your owners, 7 days that it has to be on the website as well. Board meetings, those notices have to be on there as well. Same amount of time as you would need for the notice needs to go on that app. Retention policy, the association shall adopt written rules governing the method or policy by which the official records are to be retained and the time period such records must be retained. I would suggest you just talk to your attorneys, put together a policy. You are supposed to already have it. Put together a policy basically following the statute. There you go. Then you have it. That policy or those rules or whatever it is has to be also on your website or on the app. Again, website, app, interchangeable here, guys. Portal, whatever we're saying. Law enforcement subpoenas. This is an interesting one. And again, once you know why these are here, it all starts to make a lot of sense. If an association receives a subpoena for records from a law enforcement agency, the association has to provide those records or make the records available within 5 business days. So that's a little different than your regular, official records request. If you get a subpoena from law enforcement, 5 business days, and you have to assist the law enforcement agency in its investigation as much as you can, basically. Again, once you know where these come from, those random changes that may seem random aren't so random anymore. All right, let's get into board member certification, continuing education requirements. We talked about a little bit of this where, we talked about for the CAMs, but now let's talk about it in the world of board members. All right, Chapter 718. So we're in condo world, condo board members. Pay attention for a few minutes. Board member certification now requires, you might remember it used to be class or, sign an oath. Now you need the written certification that you read the governing documents, you're going to uphold them, you're going to follow your fiduciary duty, and you have to attend a division approved educational course. It's no longer one or the other. It's you have to do both. You have to sign this certificate that you read your documents, you're going to abide by them and enforce them, and you've attended the class. So both, 2 things. All board members have to be certified within 90 days of being elected or appointed. You can do it up to 1 year prior. So you could be taking, a board cert class now, even though your, annual meeting might be whatever in December. That certification is valid for 7 years after it's issued, as long as you stay on the board for that long. Board member certification course has to be at least 4 hours long. If you guys think today's 2 hours is long, ooh, that board cert is no joke. 4 hours long. We didn't do that. Don't blame me. I don't love it either, but it does cover a lot. I understand why it does actually take 4 hours. You have to provide instructions on milestone, on structural integrity reserve studies, elections, record keeping, financial literacy and transparency, levying of fines, notice, and meeting requirements.
And I'm not going to tell the DBPR this, but we could actually use more than 4 hours for all that class, but my lips are sealed.
Oh, if we really start getting into, details of these things, we could talk about this for 8 hours, but
all day.
we won't don't tell them that.
I won't.
It is meant to be a 101 course, guys, because you just got to get certified. So you have sort of your basic understanding of those things, but it is a requirement and it's 4 hours long. So it's no joke. If you sign up to, be on the board, that's just number one fun obligation you have there. If you were elected or appointed before July 1st of 2024, then now you have till June 30th of 2025 to get that done. So, keep that in mind. Developer appointed board members now have to be certified as well. Every year after getting certified, board members have to do continuing education now. So again, it used to sort of be, hey, I took that class online, or hey, I signed that certificate and I'm good on my board, forever and ever and ever. Nope. Now every year you have to do these continuing education classes as well.
And no, we do not yet have direction from the division.
Right.
On what these board member continuing education classes need to be. So I know we're going to get a ton of those questions too. I just want to mention this class now is great for board members, but in terms of credit and CEU, today's class is only going to cover credits for CAMs, not yet for board members. We are still waiting for that. I suspect as we get closer to the June 30th of 2025, I suspect as we get closer to that date, we will start to know about what the board member CEU requirements are going to be. So
right.
Back to you.
No, thanks for weighing in, because you're right. We are for sure going to get that question. Hey, does this count? So bottom line, we don't know. Not now, at least. So yeah, also the association has to keep proof of those written certifications and the educational certificate for 7 years, like we said, or for the duration of the director's uninterrupted term, whichever is longer. Keep in mind, if for some reason you don't have that certificate, it doesn't mean that, hey, that director voted and he didn't have a certificate, so everything's void. Nope, that's not the case. The validity of the board action is still fine. All right, switching gears. Now we're back to HOA world, chapter 720. Same topic here, board member certification. All right. This is a little different because they didn't require 4 hours. The understanding seems to be sort of, well, if the condo is 4 hours, should the HOA be 4 hours? We don't really have an answer for you, but they didn't specify. We are doing the cert and we're able to do it in under 4 hours, so don't tell anybody. A newly elected or appointed director has to do, again, within 90 days, a board certification course. Just the written acknowledgement, the oath, the Scout's honor that I read my documents, I'm going to uphold them, blah, blah, blah. That's no longer going to cut it. The certificate of completion is valid for up to 4 years. You have to do the education at least every 4 years. Department approved educational curriculum has to include, again, training related to financial literacy, transparency, record keeping, levying of fines, notice and meeting requirements. So sort of, again, your basic general how to operate an HOA 101. Now, again, keep in mind what we were trying to avoid, board members doing wrongful things. So we're not going to necessarily make it easy to be on a board. Keep that in mind too. But we want everyone to know what they're doing and to be able to be educated and operate their associations. If we're talking about an association that has fewer than 2,500 parcels, a director is going to have to do 4 hours of continuing education annually. If it's 2,500 parcels or more, now we're at 8 hours of continuing education annually. So again, it kind of makes sense. You have a bigger community, you have probably more on your plate, you need to do some more education. If you don't timely file those educational certificates, you are suspended from the board. Yeah, suspended from the board. So it's not just, hey, I couldn't get to one in time, I'll do it next week, it's cool. You have those 90 days, but that's it. So then potentially you're suspended and your spot. Now, again, you could do the class and then you'd pop right back on the board, but keep in mind that that deadline is, no joke. The association has to retain those educational certificates for 5 years. Again, if you don't have that certificate on file or whatever it is, it doesn't mean that the action is invalid by that alone. All right, let's jump into some more HOA stuff. This year, oddly, well, I guess I should say it this way. Last couple of years, condos have been sort of on the forefront. They've been, in the big changes, lots of the legislation. Obviously, you guys, unless you've been living under a rock, you know all about some milestones, some CEUs, some things that you've heard probably in the news, even if you're not in a condo or don't have a condo, you've probably heard about these things that have been, percolating in Florida for the last couple of years. All of that was after the tragedy of Surfside. That was the focus of the legislature. A lot of these things were to make sure our buildings are structurally sound. We have put in all these new requirements to do these studies, to do these inspections, to make sure we're, keeping the buildings, the condos safe. Okay. Now we kind of turned our focus, once we kind of got that all set up, now we have a lot of changes in HOA world in chapter 720. 720 had kind of been on the back burner for a little while, but now we have some HOA changes. And a lot of this too has to do with the trend of being a lot more owner friendly. Let me say it that way. So a lot of these changes, if you're on the board, you may not love them. If you are an individual homeowner and you want to know more about your rights, you might be very happy to hear some of these changes, but let's dive in. First thing, and this was a nice one to put in the statute here, or to clarify for everybody here. House Bill 1203, Chapter 720. Ultimately, we get this question a lot. Hey, I'm on a board. What does that mean? I have a fiduciary duty. I know people tell me that. What does that really mean? What's the breakdown? What's a fiduciary duty? All right. So if you're an officer or director, you are subject to a section in 617 of the Florida statutes. 617 has to do with not-for-profits and operating not-for-profit associate or corporations. You guys are running a business, keep in mind. Operating an association is running a business. It feels a little different because you're not worried about profits in that same way, obviously, but you're running a business. So when you're on a board, you have this fiduciary duty and you are subject to that language in 617 of Florida statutes. It's outlined here, and essentially, basically this says, as a director, as an officer, you shall discharge your duty in good faith, with the care of an ordinarily prudent person in a like position that would exercise in similar circumstances and in a manner he or she reasonably believes to be in the best interest of the corporation. So you have to act in good faith. You have to basically behave in a way that another rational, reasonable human would, and in the way that you believe is in the best interest of your corporation. But in this case, it's the association. So you're not to act, in your own personal best interest necessarily. Obviously, sometimes those two things are at odds. You may know the association needs to do this project. We need to fund it. We're going to have to adopt a special assessment. Obviously, your personal interest may say, but I don't want to pay a special assessment. I don't want to pay more money. Well, which hat are you wearing at the time? Special assessment is best for the community. That's what you got to do. And again, it's what a person in your circumstances that would know same information you have, how they would act. Now, keep in mind, great minds don't always think alike. You may have the same set of facts. Board members disagree all the time. You may have the same report and think, well, we should adopt the special assessment and do it this way. Someone else may say, we should do this other project and put that project on the back burner because I think this one's more important for XYZ reasons. Or let's take out a loan instead of doing the special assessment, right off the bat. We could take out a loan to pay that back over more, a longer period of time and special assess that way. All of these variations for various decisions that board members could make, you could disagree and still all be exercising your fiduciary duty properly. It goes on to say, basically, you can rely on information, reports, opinions, all of that are from your experts. That's really what we're always going to tell you, talk to your experts when we're trying to make decisions. That could be your legal counsel, your accountants, and then anyone else who's qualified. So if we're talking about, again, projects or whatever it is, maybe you need to talk to engineers, architects, contractors. You can also rely on, reports from your committees. Perhaps you've assigned a committee to do some background, on whatever it is, maybe a landscaping committee to come up with some project ideas. You can rely on the information they've presented you. You're not acting in good faith if you have knowledge that's basically to the contrary and you're not following this advice. You have to be careful about things like that. If you happen to have information that basically goes against what others are telling you or whatever it is, investigate further. Don't just kind of go with the flow. Financial reporting. This is important. They modified this a little bit because, again, I hate to keep harping on it, but I think the context is important for you guys. Again, we want to make sure money is being handled properly. So this is important. Financial statements are based on total annual revenues, typically. So $150,000 or more, less than 300. It's the lowest level of financial reporting. That's compiled financial statements. From 300 to 500, it's reviewed financial statements. That's sort of a level up. Beyond 500,000, you have to do an audited financial statement. Now they've changed. This is where one of the changes is. If you have at least 1,000 parcels, you have to do the audited financial statement no matter what. Regardless of what your total annual revenue is, if you're 1,000 parcels, you're doing an audit. You can reduce the level that you're doing of your financial reporting, but that has to be approved by a majority of your voting interests present at a properly called meeting. And essentially you can kind of move down a level. Now, change here too, if you're 1,000 or more parcels, like we said, and you have to do the audit, that's it, period. You're doing the audit. You cannot prepare a lesser financial statement for consecutive years. Because again, we just want to make sure everything with the money, we want to be transparent. So you can only really waive for the 1 year, and then you're going to have to do whatever your revenue actually would require. You could go every other year, but can't do 2 consecutive. Debit cards. This is another interesting detail we've added here. Can't use a debit card issued in the name of the association for the payment of any association expenses. A person who uses a debit card issued in the name of the association for an expense that is not a lawful obligation of the association commits theft. So again, you're going to hear us talk about a lot of crimes today. Now, lawful obligation of the association is actually defined. So basically it means an obligation that's been pre-approved by the board, reflected in minutes, or in the budget. So that's really not one that you could ratify later. Oh, that was fine. We voted on it later. You could use the debit card to pay for XYZ. No, just don't use the debit card. Just full stop. Don't use the debit card. Financial accounting. This is an interesting change that they added here. A parcel owner can make a written request to the board for a detailed accounting of any amounts he or she owes, basically. The board has to provide that information within 15 business days after receipt of the request. So this is a little different. This isn't, a standard records request. This is a totally new thing now. So a written request to obtain an accounting. Now, if that parcel owner makes a written request, all well and good. They can't do it again for another 90 calendar days. If the board doesn't respond within 15 business days, the penalty is kind of interesting. It doesn't mean the entire balance is wiped out. It doesn't mean that owner now has a free for all and they have a zeroed out account, but it is a waiver of any outstanding fines of that person. So potentially that could be a serious penalty if you had some significant fines. So keep that in mind. That's a new thing that we've just new obligation for the association here. Kickbacks, other illegal acts. Again, this goes along with the theme we've been talking about today. An officer, director, manager may not solicit, offer to accept, or accept a kickback. And then we've defined kickback, anything or service of value for which consideration has not been provided for an officer's benefit or that of his immediate family, for any person proposing to or providing goods or services to the association. We hear it all the time. There's always, those stories of, hey, the clubhouse needs a new roof and it looks really interesting that we're getting bids, but the president has seems to have gotten a new roof in this meantime, in the meantime. Now, again, does it actually mean there was anything improper going on? No, but possibly. We want to make sure we avoid those situations. Can't take anything from a vendor, bottom line. An officer, director, manager who knowingly solicits, offers to accept or accepts anything of service or value or a kickback commits a felony of the 3rd degree. If the board finds that somebody has violated this, one of the board members has violated this, the board must immediately remove that officer or director from office. The vacancy is filled according to law. So again, depending on what your bylaws say, or if you just appoint somebody to fill that spot. The caveat here, there is an exception. Directors can accept any food that's consumed at a business meeting with a value of less than $25 per individual, or any good received in connection with fair trade or educational programs. So if we were here in person, I would have had some stress balls for you and some pens and other, tchotchkes. That would be fine. Don't worry, I'm not trying to bribe you, I swear. All right. If you are charged, so now we're sticking with the kickbacks and illegal acts here, a director or officer charged by information or indictment. So that's interesting. It's information or indictment, but it's only a charge. It's not a conviction necessarily, a charge. With any of the following crimes must be removed from office and a vacancy declared. So it's sort of one of those, guilty before, guilty upon, whatever. Forgery of a ballot envelope, voting certificate used in an election, theft or embezzlement involving association funds or property, destruction of or refusal to allow inspection or copying of official records, obstruction of justice, and any other criminal violation. All right. Now we're going to switch gears a little bit. We're still in HOA world, but now we're talking about ACC, ARB, whatever you guys want to call it for your community, your architectural control covenants. So that might be your ACC committee, your architectural committee. It might be what the board does, but it has to do with your architectural review authority. Essentially, the authority that the association has to review any of these architectural changes, construction, improvements, alterations, all of that, that needs to be what's in your governing documents. And really, it's only what that authority is in your governing documents. Let's start there. But really, that authority has to be for the, to enforce it, the owners need to have an idea of what the requirements are. So really, it's always been, you have to have some plans, you have to have, or not plans, you have to have guidelines, specifications, so that when owners submit their plans, they know what's going to be approved, what's not going to be approved. Location, size, type, appearance, those things should be in a published set of guidelines and standards that the deck authorizes. That's already sort of what we've been dealing with. And we tell clients all the time, knowing what your guidelines are, what your standards are, that's very important. If you have a deck that basically says the board gets to decide any modifications to the lot, what does that mean? What's a modification to, does that mean paint colors? Does that mean landscaping? What are our criteria? What are our guidelines? Maybe you have a rule or a guideline that says no fences higher than 6 feet. Okay, does that mean it's a free for all in the world of fences? Can I put up a chain link fence? Can I put up a wood fence? Can I put up a PVC fence? Does it have to be painted if it's wood? All of these different things. I wouldn't know if your rule is only no fences higher than 6 feet. And if you want to come back and tell an owner, oh, that means wood fences only. Well, it doesn't say that. How would we know it's wood fences only? Does that mean shadow box fencing? Does that mean plain wood fences? All of these variations. If you only want wood fences, if you don't want chain link fences, if you don't want those PVC fences, if you want wood and it has to be stained and it can't be painted or whatever it is, have these guidelines, have this criteria already established. That's the only way your owners are going to know what's going to be approved. That all makes sense. That's kind of been the way we've been operating for the last couple of years anyway. But now we're getting into some more details here. Now, essentially, you have to be very careful too about what we're enforcing. And I'll sort of, I don't want to get too into the weeds with this, but there is a legal argument here when we talk about some of these changes to the statute that I want to touch on briefly, but it's just something you need to be aware of. There's something called Kaufman language. You may or may not have heard about it already, because now it's something we do talk about in these classes. Essentially, it means if you have language in your documents and your declaration that says that your declaration is subject to Chapter 720 or Chapter 718, if we're talking about a condo, Chapter 720, as it's amended from time to time. That's the magic language, as amended from time to time. That's the Kaufman language. That means your declaration changes with the statute. Will follow what the statute says. If your declaration was recorded in the year 2000, you might have the question of, well, wait a minute, do we follow Chapter 720 as it was in the year 2000, or do we follow 720 as it is now? And there are variations, there are various legal arguments that have to do with what the change may be. But this is something to be aware of, because if you don't have that Kaufman language, there may be arguments of you only follow what the statute said back then, and certain changes that are coming in or that are being put in the statute now, there might be an argument that you don't have to follow those. You need to talk to your attorneys about that if the next couple slides we go through, bother you, basically. If you don't want to hear what I'm about to tell you, there might be an argument that it doesn't apply to you, but it would be something that would be in your governing documents, and you really need to talk to your attorneys about it. So, with that disclaimer, the change to the statute now says basically that association can't enforce a covenant or a rule or a guideline that limits or places requirements on the interior of a structure that's not visible from the parcel's frontage or an adjacent parcel or an adjacent common area or community golf course. Can't require the review and approval of plans for AC, HVAC systems, things of that nature. If such system is not visible from the parcel's frontage, an adjacent parcel, an adjacent common area, community golf course. Now, those things do make sense in that if they're essentially not visible to anyone else, why should it require board approval or architectural control approval? But that was new. That's new to the statute now. Another thing to be aware of, this was a new change. Now, if you deny an ARC request or ARB or ACC, whatever it is, when we're talking about some architectural request, if it's denied, it used to be that essentially you would just get a denial, send a denial back to the owner. Nope, we don't approve your, whatever, your new paint color. It didn't necessarily indicate why. Now the statute, although it was recommended, now the statute says you have to give written notice to the parcel owner stating with specificity the rule or covenant upon which the association or the committee relied when denying the request. So it's not as, kind of loosey-goosey in terms of, well, we just didn't like what you were proposing, so we said no. We didn't like your new, paint color, so we said no. That's not going to fly anymore. You really need to know, well, we have the authority to review paint colors under this, and you really should have those guidelines. Our paint colors are this list, and you didn't pick one. That's the easiest way to make sure there's not going to be a challenge. So talk to your attorneys and make sure you guys are, on the same page with this when we're talking about enforcing these ARC guidelines. Another one that was new and was tweaked this year, but really came into play, I think 2 years ago now. No sense of time anymore. I'm going to say 2 years. But again, this is another one where that Kaufman argument might come into play. Regardless of any covenant or requirement of the association, and unless prohibited by local ordinance or general law, the association may not restrict parcel owners from installing, displaying, or storing any items on the parcel which are not visible from the parcel's frontage, or an adjacent parcel, or an adjacent common area, or a community golf course. Those were the changes. They didn't have golf course in there before, including but not limited to artificial turf, boats, flags, vegetable gardens, clotheslines, and recreational vehicles. They also added, I think, specifically vegetable gardens and clotheslines. Now, for a lot of our, neighbors in Central Florida, or even some of the properties out a little further west, maybe that kind of makes sense. Hey, what I keep in my backyard should be my business. The association shouldn't have any say in it. And as long as you can't see it from the front or from the side or from the back or whatever it is. Okay, I understand where that argument comes from, but being in South Florida where our lots are really small and we're kind of on top of each other, and we have a lot of associations that have a lot of covenants and restrictions about what you can and cannot put even in your backyard, whether it involves installing, sheds, things like that, putting a boat in your backyard, keeping an RV on the side of your house. So again, these are now covenants and restrictions that we have a lot of boards, very upset about. That, wait a minute, why can't we enforce this? This has been in our documents forever. Well, now this is what they put in the statute. So again, if that's something that really, sticks out to you as something you want to be able to enforce, see if there's a way with, again, there might be a Kaufman language argument you can make where maybe this new statute that says you can't enforce those covenants could maybe still be enforced in your community. So again, it's certain things in the backyard that aren't going to be visible from the front or the side or, an adjacent common area. And word on the street is there was some guy in charge of the legislation who wanted to keep a boat in his backyard, and that's why we have that new change. I don't know. That's the rumor. So some more changes to HOA world, some other changes that I, again, have board members not very happy about at all. And maybe, again, there's a Kaufman argument here somewhere. Talk to your attorneys. But the gist is the statute now says for certain things, you can't fine or suspend use rights. So it's for garbage cans, leaving garbage cans at the curb or the end of the driveway within 24 hours before or after garbage collection. And holiday decorations, if you leave holiday decorations or lights up, basically, unless it is 1 week longer than the association has provided notice to that owner, there's a little bit of leeway there to make somebody take them down. But as silly as it sounds, garbage cans, it does makes a big difference in some communities where they want to be able to fine if you leave your garbage can out. I mean, I have a client that is, they're townhomes. So obviously, as you can imagine, there's small footprints. Those driveways are, very close together. And we're very fortunate that they have 2 days of garbage pickup. That is nice in a week. But that means if you can't find the day before or the day after, and you have 2 days of garbage pickup, that's 6 days that someone could just have their garbage can out. And if you're in a community like that, where it's townhomes, that's a lot of garbage cans that are just, up and down the sidewalks. They're the driveways and they're basically on top of each other. That's not very cute. The owners were not very happy about that. or the board members are not very happy about that. But that, you know, occasional owner doesn't like to get his garbage can inside. I'm sure he'd be very happy about it. And again, the way they wrote this is strange. It's that you can't levy a fine or a suspension for that type of violation. It doesn't mean you can't enforce the violation some other way. You can still send a letter if that were something that, you know, you had as a covenant in your community or a rule. You could still potentially pursue legal action in court for it. So again, sort of strange, but just something to be aware of. This is the other one that really, really set people off in the world of HOAs. And I did actually see a couple articles on this that were geared the other way or angled the other way, where now, hey, guess what? Owners can now park their trucks in HOAs and there's nothing the association can do about it. That was the slant on one of the articles I saw. Now, again, similar argument, Kaufman argument might apply to you if you already have restrictions against trucks in your community. But now the statute says we have some prohibited clauses in association documents. Governing documents cannot prohibit a property owner or a tenant or a guest from parking his or her personal vehicle, which can include a pickup truck, in the driveway or anywhere else where basically that vehicle is allowed to be. Work vehicles, you can also park a work vehicle. Same thing, can't prohibit a property owner from keeping their work vehicle in a driveway. Now, that could be something that typically would be considered a commercial vehicle in the world of HOAs, where a commercial vehicle might be defined in the world of the HOA, might be defined as anything with lettering, signage, visible tools, ladders, whatever else. But now the statute says, too bad, that's their work vehicle, that's fine. The only exception is if it's a commercial motor vehicle, and they use a very technical definition of what a commercial vehicle is. That is not the definition that most associations use. So that's something also to be aware of. The truck restriction thing is a big deal for a lot of our HOA clients. Also something to be aware of, governing documents can't prohibit a property owner from basically bringing a contractor or worker in just because that person or that vendor is not on the preferred vendor list. You also can't prohibit an owner from allowing entry to a contractor or worker just because that contractor or worker doesn't have a professional or occupational license. Can't keep them out, have to let them in the gate. Oh, like I said, this vehicle restriction with the commercial motor vehicle, there's a whole long definition here. Basically, they use it to mean, you know, massive sort of, you know, like 18-wheeler kind of trucks. Fining committee, grievance committee, there's some changes here as well. Again, remember, a lot of these changes tend to be a lot more owner friendly than has been the trend. So that continues with what the changes we made to the fining process as well. After a fine or a suspension is levied by the board, so remember now, guys, to adopt a fine properly, it's adopted by the board first, then imposed by the committee. So 2 steps, board first, then it goes to the committee. There's a 14-day notice required given to the owner to give them that 14 days before they're going to appear before a hearing committee or the, you know, grievance committee hearing, however we want to phrase all of that. So 14-day notice to the owner. The hearing must actually be held within 90 days after issuance of that notice. The committee, that hearing or grievance committee, finding committee, whatever we're calling them, has to have 3 members appointed by the board. They can't be officers, directors, employees of the association, or any sort of spouse, parent, child, brother of an officer, director, employee of the association. I know that eliminates a lot of people. I know people don't want to be on the finding committee. I don't know what to tell you with that. I get that question a lot. We don't have anyone who wants to serve on our finding committee. What do we do? I don't have a magic wand. You just have to convince people. And if you can't find people to be on your finding committee, then guess what? Can't find people. So here we are. Electronic hearings are okay. You can do your finding committee hearing via whatever, some Teams platform, Zoom platform, whatever it is, you know, whatever you want to use. That's okay. It doesn't have to be in person. Within 7 days after the hearing, the committee has to basically give that owner a written notice of what their determination was. It has to also indicate, and this is an extra little detail, how that parcel owner can still cure that violation. So if there's a violation that was, you know, you have to pressure wash your roof or whatever it is, the owner doesn't do it, the owner doesn't do it, the owner doesn't do it. You've given them opportunities. You finally adopt the fine. You finally send it to the fining committee. Here we are, fining committee looks at pictures, looks at, you know, the board's notices. Roof still looks dirty and it's been, you know, 2 months now. Okay, we're imposing the fine of whatever it is, $1,000, because we did $100 a day for 10 days. We're confirming the $1,000 fine. You send the guy a notice. We've confirmed the fine. We find your roof is dirty, needs to be pressure washed. But that's the important step. You have to tell them how to still cure it, if it is something that can be cured. And then give them the date by which the fine has to be paid. That's another one. Has to be with 30 days after delivery of the written notice of those hearing results. Another interesting thing, ultimately, if they don't cure the fine or cure the violation, sorry, the association eventually can get reasonable attorney's fees and costs, but they're not going to during this fining process. The attorney's fees and costs can't accrue until after the date that notice was sent, demanding basically payment for the fine. All right, we're back into the world of fraud, election fraud, voting fraud, all that good stuff. More criminal penalties here. Fraudulent voting activities related to association elections, penalties, all of that. So new sections of Florida statutes or in 720 here. So again, we're still in HOA world, guys, HOA world. So any of the following acts of fraudulent voting activity, you commit a misdemeanor of the first degree. Willfully, falsely swearing or affirming an oath or an affirmation to basically arising out of voting activities. Perpetrating or attempting to perpetrate, aiding in the perpetration of fraud in connection with a vote to be cast or attempted to be cast, preventing a member from voting, changing their ballot envelope, their voting certificate, any of those things. Menacing, threatening, using bribery to coerce people's vote, any sort of corruption in the voting process, promising, you know, bribes, again, giving or promising directly or indirectly anything of value. That doesn't include food served that, you know, is at an election rally or something like that. It doesn't include, you know, anything used as election advertisements. So if you give out stickers or buttons or whatever, that's fine. Any threats, any, you know, threatening violence or intimidation, any of that to influence a ballot, all of those things, not okay. They are crimes. Don't do them. May sound silly when we're just talking about an HOA election. Who would be that concerned? Well, if you are that concerned and you're doing those things, you're committing a crime. And it was probably because there were some other crimes involved, but I don't know. All right. New criminal penalties. These were some of the changes. Misdemeanor of the first degree again, knowingly aiding, abetting, or advising a person in the commission of a fraudulent voting activity related to association elections. Agreeing, conspiring, combining, confederating with at least one person to commit a fraudulent voting activity related to elections. Having knowledge about this and giving any aid to that offender with the intent to avoid or escape detection on blah, blah, blah. Important little caveat here. I appreciate that they put this in there. Doesn't apply to a licensed attorney giving legal advice to a client. All right, switching gears a little bit. We're talking about assessments, lien claims. Again, some of these are kind of one-off slides, but interest, they addressed interest this year. If no rates provided in the deck or the bylaws, it's simple interest. It accrues at the rate of 18%. Compound interest can't be used. Electronic voting, talk about that very, very briefly. Basically, you can do elections and membership votes through online voting. But now a member can consent. Before you had to consent to start online voting, and that was in writing. Now they've changed that you can consent electronically or in writing to start using the online voting process. Online voting process really hasn't changed in the last couple of years. You still need to make sure you're actually using a platform, a vendor that knows what they're doing. It's not something where you just get to vote, you know, oh, Mary's going to send me an email telling me what she wants to do. That's not how it works. There's an actual platform. You have to register. that has to make sure it, you know, confirms the identities of everybody using it. There's a lot of regulations involved there to do it properly. Some other things, other changes in the world of HOAs, some other little changes, but again, it could make a difference. You can't prohibit a first responder. It used to say law enforcement officer. Now it says first responder, basically from parking their assigned first responder vehicle in an area where they can park. So again, if you, before when it said law enforcement officer, we occasionally we get that question, hey, can so-and-so park their, you know, sheriff's car here? Yes, bottom line. But now law enforcement officer expands that a little bit. Basically now it includes, or from law enforcement officer to first responder, it includes more categories of individuals who may be able to park their vehicles. EMTs, firefighters, paramedics. Now those vehicles can be parked in the community as well. All right. Let's get into some other little details here. This is kind of now, oddly enough, now this is sort of old news. Before October 1st of 2024, so whatever that is, 3 months ago, you were supposed to send out, if you're in an HOA, copies of your rules and covenants. And that's how they worded it. I don't know why. Send a physical or digital copy to every member of the association. You could also just send, well, we'll get into this, I guess. So you had to send a copy to everybody before October 1st of 2024. Hopefully, again, you've done that. You could also do it. You'd meet the requirement if you posted the copy of your rules and covenants to your website, and then you send a notice out saying, hey, those are available on our website. You can go look here for all the rules and covenants. And you have to keep that updated. Obviously, if you change any rules, change any covenants, make sure those are updated and posted on your website. I know one community sent out cute little postcards to all of their owners. And it just said basically, here's our website, www.whatever. We have our rules and covenants posted. Go take a look. All right. This is another one with the ARC requirements. This has to do with hurricane shutters. Basically, now you have to adopt, well, I shouldn't even say hurricane shutters. You have to adopt hurricane protection specifications for each structure. If you have ARC requirements, now part of that is we also want you to adopt specifications for hurricane protection. So that could be shutters, but that is beyond just shutters. You have to include color and style of the protection products. Everything needs to comply with the building code. Talk to your attorneys a little bit more in detail about all of this. You can require that the parcel owner adhere to a unified building scheme with these things. Hurricane protection involves, like I said, not just shutters, but roll down track storm shutters, impact resistant windows and doors, polycarbonate panels, reinforced garage doors, exterior fixed generators, fuel storage tanks, all of these things that, you know, now sort of part of the hurricane protection realm. All right, switching gears. So that was all of our big HOA news, which again, some of that may not have sounded, you know, like it was anything too major, but ironically, a lot of that we hear from our board members all the time that a lot of those changes actually do impact their communities, and they are maybe not so thrilled with a lot of them. But all right, condo world. Let's get into it. So 1021, again, we touched on a couple of these topics essentially. Mandatory structural inspections, which we also just call milestone. You hear me say it all the time, milestone inspections. The milestone inspection, they extended the exemptions. So a milestone has to be done for any building that, or any condo that is 3 stories or more. But there is an exception to single family, 2 family, 3 family, and they added or 4 family dwellings. Okay. They added some definitions, clarified some definitions in chapter 718. Made some other changes in terms of if you're a condominium that's in sort of a mixed use building. Electronic voting, we get into some of that. The thing to know about with the electronic voting change, or the change to the electronic voting process for condos, and this is strange, I'm not entirely sure why they did this, honestly. Once you have given your owners the opportunity to vote electronically, now you have to keep giving them the opportunity to vote electronically. The association can't refuse to let someone vote electronically if they already let them do it once. Okay. And you can also consent to using online voting by email as opposed to just, you know, a good old fashioned signed piece of paper. Also applies in co-op world. All right. Some of this is a little bit of what we talked about, you know, in HOA world, but same idea, sort of same trend going on. Kickbacks, again, those are a no-no, guys. Officer, director, manager who knowingly solicits, offers to accept, or accepts a kickback commits a felony of the 3rd degree, must be removed from the office and a vacancy declared. Felonies are no joke. 3rd degree punishable up to 5 years in prison and a monetary penalty of up to $5,000. Okay. Insurance is another thing we have to be worried about. If the association, upon receipt of a complaint that the association does not maintain proper insurance or fidelity bonding, the division will investigate. They must monitor the association for compliance. They can issue fines and penalties. Financial reporting, again, same kind of thing we talked about before. Membership can vote to do a lesser financial reporting level, but you can't do it in consecutive fiscal years because, again, we want to make sure we sort of keep an eye on what's going on with everyone's money. Debit cards, bottom line, don't use a debit card. That's all you need to know. All right. Bylaws, there were some changes to this section, 718.112. Now there's a new requirement that you have to have quarterly meetings. A residential condominium with more than 10 units has to meet at least once a quarter. So 4 times a year, the meeting agenda has to include an opportunity for members to ask questions. Now, the right to ask questions with respect to designated agenda items, it also includes the right to ask questions about reports involving the status of construction or repair projects, status of revenues, expenditures, and then there's sort of a blanket and other issues affecting the condominium. Now, it does not specify that just because owners get to ask these questions, that the board needs to answer them. You know, if you're getting questions sort of randomly, you might not be prepared to answer them. But also, it doesn't say you have to answer them. So, interesting. They've added this right of the owners to ask questions, but I don't know how effective it's going to be. If a condominium board meeting agenda item relates to the approval of a contract, this is an important thing to be aware of too. The copy of the contract must be provided with the meeting notice and made available for inspection. And then also, again, on the app and all of that good stuff. So that's been an issue. That's been some there's been some confusion there in terms of, you know, posting potentially an engineer's AIA proposal that could be, you know, 100 pages with specs and all of that. Do you post that on your, you know, bulletin board in the lobby? How do you post a 100-page proposal on the lobby with your notice that says we're having a board meeting in, you know, 48 hours? Interesting. The recommendation, you know, a lot of people have said post it if you can. If there's not space to post 100 pages of a contract, maybe have a reference to a link or a QR code or whatever else, and make sure you do put it on your app or on your website or whatever it is. So you can say you tried to comply, you did post it with the notice or tried to post it with the notice. We're hoping that gets some clarification in the next session because that's a very odd little detail. Structural integrity reserve studies. So this is sort of a new notice requirement, so to speak. Basically, once you do your SERS, the association has to distribute a copy of the study or a notice that it's available to every owner. Director and officer offenses, guilty until proven innocent, we say. If the director or officer is charged by information or indictment with any of the following crimes, they're removed from office, must be removed. So again, this is similar to what we said before. If they're charged, doesn't mean found guilty. Only says charged. Forgery of a ballot or a voting certificate, theft or embezzlement of funds, destruction of official records, all of those things. And this is an interesting one too. When the charges are pending, the officer cannot have access to any official records except pursuant to a court order. Fraudulent voting activity. You see the trend, another trend we're talking about today. Person who engages in the following fraudulent voting activities It's punishable as a misdemeanor of the first degree, which means one year in jail potentially. Willfully, falsely swearing to, affirming, an oath related to voting activities. Basically, it's the same list that we've gone through: threatening, bribery, promising inappropriate things, basically to have an impact on an election. Like we said, threatening, violence, all of that. And that picture on that slide creeps me out like I can't even tell you. So we're just gonna soldier on.
You're welcome.
Right? I don't like that one. All right. Hurricane protection. So we're still in condo world, guys. Hurricane protection is the new term instead of hurricane shutters. They've added that and changed that a little bit. Now, again, you need to have your specs. You need to know what's going to be approved. Essentially, we've clarified hurricane protection is not going to be considered a material alteration. We can, skim through some of this a little bit. Your documents are still going to, outline who's responsible for what in terms of hurricane protection. If it's the association, if it's the owner, you can vote to change those things. You can modify your declaration, all of that. Interesting to know, we'll get into this slide here. If ultimately the association needs to do, and it comes up really in the world of concrete restoration, if the association has to do certain repairs to work or, to do the work that the association is responsible for, and they have to remove hurricane shutters maybe to do that work. So again, maybe you're doing some concrete restoration, you need to get to certain balconies, whatever it is. The association's responsible for that exterior envelope, for the slab, all of that. But maybe the owners in your building are responsible for, or you put up shutters. Now, the board ultimately needs to figure out, the engineers are going to tell you, your experts are going to tell you, hey, these shutters need to come down in order for us to do the work. Interesting here. So the unit owner is not, even if that unit owner put those shutters up and it was the unit owner's obligation to take care of, shutters and windows and whatever, the unit owner is not going to be responsible for the cost of the removal of that hurricane protection if that removal is necessary for the maintenance, repair, replacement of essentially association property for which the association is responsible. So again, if you're doing concrete restoration and you have to take down shutters to do that concrete restoration, you can't say, hey, unit owner, we need you to take down the shutters because you put them up, because we need to do this concrete restoration. Now, it's the unit owner's not going to be responsible for that. The association is going to be responsible for that cost. The board basically can determine now if that hurricane shutter, whatever, can go back up. If removal and reinstallation is completed by the association, the cost cannot be charged back to the unit owner. If that removal and reinstallation is completed by the unit owner, the association has to actually reimburse the unit owner the cost of that removal and reinstallation, or issue a credit, basically. So that's interesting. That was an interesting sort of shift. And that's regardless of what the language is in your governing documents. So interesting one to be aware of, especially now in the time of doing all of these big inspections, all of these big projects, concrete restoration, all of those things. All right, hurricane protection. There's some more on here that you might want to look at. Statute of repose. This was another one that, again, seems like a very sort of minor change. It's only one little slide, but it's important because ultimately the impact could be significant for you guys if you're a newly turned over condominium. If you've been around for a long time, this probably doesn't affect you in the slightest. But basically, the statute of limitations to bring an action, essentially, the statute of repose for any construction defect involved, against the developer for basically building your complex here. In previous years, it was limited to 7 years, but that was measured from the date of the certificate of occupancy. That is generally an older date from when turnover actually occurs. Now you're given more time. You have a longer period of time to bring an action against the developer when we're talking about 7 years from the new requirement, which is 7 years from turnover. So that's important, again, if you're a new condominium or a recently built condominium. SLAP suits. This is another change that is pretty significant because this has been around for a while. SLAP suits. It's a retaliatory action by the association when an owner complains to local government, the association turns around and sues that owner. Now we've cleaned up that language a little bit. We've added some new language to it to make it a little bit more difficult in the world of the associations to pursue actions against these owners who sometimes are just really problem owners. We'll call them, I think Jeff Rembaum called them cantankerous owners. We'll say that. Everyone knows the problem owners in their community. Now, in order for a unit owner to raise the defense of some sort of retaliatory conduct taken by the association, that unit owner must have acted in good faith and not for improper purposes, such as to harass or cause unnecessary delays, essentially to the association. So again, if everything is done in good faith, all well and good, but again, that's a tough measure when we have these problem owners who I do think often like to just be difficult to be difficult. All right, so unlawful SLAPP suits, you have to be very careful. If you're in a condo, you don't want to bring an action against an owner that is going to be considered retaliatory or that they're going to allege is retaliatory, either because they complained about the association to the division, or they've complained about how the board is operating and things like that. It can be a little complicated. It can get a little messy. If you want to, again, go after that owner, talk to your attorney, see if that's something that, you really think you should do. A condominium association can't expend association funds in support of a defamation, libel, slander, or tortious interference claim against an owner or other claim against an owner based on one of these SLAPP suit type of things. So again, it's something where you want to be careful because you may not be able to spend association funds depending on, again, the circumstances and what we're talking about here. So it's not as easy to go after these owners, but in theory, that would only be if you're doing it in a retaliatory manner, which hopefully you wouldn't be as the association. You would only be properly going after these owners for various, wrongdoing. All right. We'll just touch on some of this stuff here. There's some other issues from 1021. Developer turnover inspection report. The CEUs was added in there. Developer also has to do it. Conflict of interest. Director who has the conflict of interest can establish quorum at the board, but to allow the vote to proceed, but he's not actually going to vote on the conflict, but his presence counts towards quorum. So at least they've clarified that. Suspension of voting rights in the world of condos. This was another change. Now you have to give a 90-day notice prior to any election or time when you're actually going to basically suspend that person's vote. 90 days prior, that person has to be told. That complicates things and makes suspending voting rights a little more difficult. Division of condominiums, they've expanded their jurisdiction a little bit. You can read through that. The criteria is there. Another interesting thing, now they have the right to attend meetings. Someone from the division may want to come and sit through your board meeting. Interesting. Some other changes here. Now, I honestly, this is now where we get into the point of the end of the slideshow here. We are supposed to, when we do the legal updates, we get approved. We are told what the things that we have to tell you about. There are a couple bills here that, in our opinion, don't really impact associations, wouldn't be of interest if you're a CAM or a board member, but I'm supposed to mention them. So they're in this slideshow, and I'm going to mention them. Okay, House Bill 429, House Bill 613, House Bill 917, Senate Bill 1600. Take a look at those in your own spare time if you're interested. But like I said, I don't think you really would be interested, but feel free. Last thing I want to sort of end on here is the Federal Corporate Transparency Act. You may hear a lot about it, CTA. It was sort of hot topic. What do we do? What does this mean? Do we have to comply? Does it apply to associations? There was a lot of chaos about this. The gist is Congress enacted this. It was a federal law, basically. And there was a lot of question about, okay, we want the beneficial owners to have to register. A beneficial owner, the definition is essentially a person who exercises substantial control over the entity. So the way that's been interpreted is that means board members. Board members are the ones who have substantial control. They vote, they control the money, whatever it is. So it was, the whole idea of it was to avoid corporations having sort of these shell companies and other things, and actually knowing who these owners are of these companies. Problem is, again, we didn't really think it was supposed to apply to associations. We didn't get clear answers on that. There was a lot of questions of, wait a minute, so do the associations have to have their board members register and actually put their personal information and, you know, on this website and all of that? And there was a lot of back and forth. There's been legislation back and forth too. Essentially right now, where it stands. So again, if you were a beneficial owner, you had to report your name, your birth date, your address, all of this. Where it stands right now, there is an injunction in place nationwide. You don't have to comply. You don't have to file this information. You were supposed to do it by January 1st of 2025, but there's an injunction. You don't have to do it. The latest is you have, you know, sort of, we're all on standby to see if anything changes. But right now, you don't have to do it. You could do it voluntarily if you wanted, but you don't have to. Okay, Jeff. I left 15 minutes for questions. You just
did
popped
great.
up. So what did I miss?
You did great on time. Folks, Jeff Rembaum has a article that he just sent out on
I was going to
Rembaum's
say, we
Association
just
Roundup.
sent the newest blast.
Yeah.
Yeah.
So if you go to KBR Legal, I'll show you how to do that afterwards, after Emily does the Q&A. But if you go to rembaumlaw.com, at the bottom, you can sign up to get his free newsletter. And he did another article this morning about how the act is on hold again. But if you're not sure, it's always best to contact your association counsel. Don't take the word of somebody without that ESQ after their name. Trust me. Emily's going to go through the Q&A to look at some of the questions that are pertinent and on topic. We're not going to get to all of them. There are literally 400 of you, over 400 of you on right now, and a ton of questions. But while Emily's looking through some of the questions, I'm going to share my screen. I just placed the link into the chat for the evaluation. So please fill that sucker out. And this is what it looks like after you click on that link. It'll take you to this page here. All right. And after you fill this out and hit that submit button, this page is going to answer a lot of your questions that you had too. This has Emily's contact information, ACE's contact information, the link to register for the summit in March, in which Mike Bender's going to talk about the upcoming legislative session and what we might be expecting to see happen there. But also, the question of the day is bullet number 3. To save the slides from today's webinar, that's bullet number 3. So this is the screen after you submit your evaluation. This is the successful confirmation screen. You click on here, a new tab opens up, and here are the slides. And again, depending on your browser, I happen to be using the latest version of Google Chrome. For me, the download button is on the upper right-hand corner. The print button is right next to it. If you can't find either of those, the old-fashioned trick always still works. Right-click on the first screen, and then you have your save and your print that pop up on the little drop-down menu there. I'll go over this much more slowly after Emily is done with the Q&A. Now, one last thing I want to mention. The required portion is over. If you made it this far and you're a manager, you're going to get your credit. We'll report the credit. Now, the one thing I do check, even if you submit your evaluations, just keep this in mind. We do check the attendance sheets to match it up to make sure you were here for almost all of it. Okay. If you came in an hour late, you're obviously here now to fill out the evaluation. We're going to check on that. So just keep that in mind. Okay. Please don't put us in the position to fudge the truth should we ever be challenged. Okay. Emily, back to you for some Q&A, and then I'll hang out afterwards and go over the techie stuff afterwards.
All right, we'll try and hit on some of these. Someone asked about records requests. Does the law specify how a records request must be submitted to the board or to the CAM? Ultimately, yes and no. In the world of HOAs, it says if it's sent via certified mail, there's a rebuttable presumption, blah, blah, blah. Condo doesn't have that same language, but basically you can adopt some rules as to how your record request should be sent in or, received. You can require certified mail. But again, if you get the records request and there's any question, if there's anything that even could possibly be interpreted as a records request, talk to your attorney, start there. Because Right, unless you have rules in place, it could be just an email. It could be, you know, somebody jotted down on a Post-it and left it for the manager. I mean, you know, it really, it could be anything. So that's hard to answer that one, but good question. Someone said, should the HOA attorney be separate from the management company? Now, generally they are. The HOA attorney should not be part of your management company. Sometimes, and I hope this is the way you're asking it, you know, we may have to, as you're the attorney for the association, we may have to answer something on behalf of maybe the management company, because generally the management company and the association, their contract will indicate that the association will indemnify the management manager or whatever it is. So sometimes there's a division complaint that is sent, you know, to Mary Jones, your manager, but it's really against, you know, whatever it is, the Greens HOA. And as the representative of the Greens, we have to answer for that Mary Jones violation. So that can get a little interesting, but yes, I mean, there shouldn't be an issue there. Your HOA attorney is your HOA attorney. Your management team is your management team. How many years back? 7 years. Generally, for your records, you're holding them for 7 years. Any governing documents, any minutes, you have to keep them basically forever. Building Link is where our records would exist. Yes, I know Building Link is one of the websites or one of the services, I guess, platforms that some of the management companies use. That may comply. I don't know, because I don't know the details about it. Someone said, can the association use the management website as their website? Potentially. Again, I don't know without knowing more about it. That may comply, that may work. The association has to have control over it though. So just, you know, maybe you can have your management team, you know, sort of running it for you, but it has to be the association's platform.
Emily, what I hear a lot too is what that person might mean. They might be with a management company that provides the service of providing websites for the association. So if that's the case, then it'll be fine, correct?
Right. Let's see.
George, you said you're not seeing the link in the Q&A. Open the chat area and I'll play it and I'll paste the link once again. So open the chat area. The chat is not to be confused with this Q&A module. It's two different things.
Our condo association recently shredded records that were old. Would they have a list of what was shredded? That is a good question. I don't know. I don't know if that's a problem or not. Let's see. If the unit owner doesn't consent to use of their email address, does the HOA now need to mail them notices such as the elevator's not working this morning? You can still, obviously, if someone gave you an email address for the purposes of communication with the management team, that's different than I gave you my email address for purposes of, you know, official notices, with the understanding that the entire membership potentially could get my email address and start, you know, sending me email blasts. Those are different things. So if you have someone's email address and you're the manager and you want to let them know, hey, the elevators aren't working today, I have no problem with you sending them an email that way.
Yeah. And folks, I just in the chat, I just placed another link for the it's a shortcut link for the roundup that went out this morning covering the latest on the Corporate Transparency Act. So you can click on that link down there and you can see the article that Emily just referenced a short time ago.
Yeah, it is actually, it's one of those things that it is almost funny because the orders coming in from the court
back and forth
issued, you know, there was one on December 26th and then one on December 27th. And that, you know, right up till when everyone's, hey, do we have to register by the end of the year? What's going on?
Getting whiplash. It's like a tennis match back and forth there. Paul, yeah, we're going to email the certificate. There are a lot of
questions too about, you know, 719. A lot of the 718 changes were also in 719, but the slides will indicate which ones apply. So go through your slides and it'll say, let's see. Yes, the official records request form, the DBPR does have one. Thank you, Paul, who posted that there. You can use that. As new board members, are we responsible for previous records that are a disaster? I hate to break it to you, but when you come onto a board, yeah, there's an element of you inherit all of the problems from before you. You just do. So yeah. Sorry about that. Sorry to be the one to break that to you. Let's see what else.
Thank you, Jackie. You're becoming one of our regulars, like in Cheers. When you walk in, we're going to have to all shout your name together.
Let's see. There's some questions that really aren't from today. I see a lot of sort of technical things that weren't things we covered today. Are ARCs required for condos? Anything that we talked about that was ARC, ARB related today, that architectural segment, that was all, you could have an ARC in your condo in theory, but everything we talked about today was in 720. So that was HOA world. Okay. I just got an email, Jeff, from Alberto Velasquez, and he said he's on his phone and he's still on the line. Please make sure he gets his credits.
Anybody who
got kicked
just
off.
listened with audio today, we know how to reach you. So your phone number will be associated with your registration link, and we'll send you the link for the evaluation, and you'll get your credit. No worries there. Back to you, Emily.
Okay. All right. A lot of stuff. Just, yeah, this is hard. Can the association limit the size of the vegetable garden? I like that question. So like we said, for whatever reason, vegetable garden was the specific little term added to that section of 720 this year that you can't have a covenant that prohibits it as long as it's not visible from the front, from the side, from the back, blah, 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 blah. In theory, could you limit the size of a vegetable garden? Sure. But again, we're into the same argument of, is it visible from the front or the back or the side? And is Kaufman language an issue? If it is visible, perhaps you can limit the size and there's no question. All various factors that could be important there. Can a CAM chair a hearing meeting, summarize the violations and make recommendations? I mean, ultimately, the way the hearing is going to go, the board, again, when we're talking about violations and fines, the board decides first. They make their decision in terms of what the fine is. Then it goes to the hearing with the fining committee or grievance committee or whatever you call it. If your CAM is the one who sort of has all the records, has the pictures, maybe they're the ones who do your inspections, they get your reports, it makes sense that they're going to be the one to say, okay, here are all the letters we sent, here are the photos, that's fine. But ultimately, you know, again, the board is going to be the one that makes the decision first, and then the board's decision goes to the committee to be essentially either confirmed or not. Is there a limitation of how long a board member can serve on an HOA? No. So there is a limit in the world of 718. Again, not something we discussed today, guys, but there is a limit in 718, which is condo world, but that starts in the year 2018 and it's 8 years consecutive. So we don't have to worry about it till 2026. Okay. The new laws regarding commercial vehicles, pickup trucks, with a large logo that covers the entire truck. Does the association have to allow the vehicle to park on the street or driveway? So Diane, you definitely are in the category of the board members who do not like some of these changes to the HOA world. That is potentially an issue. Again, I don't know if that's someone's work truck, if that's someone's personal vehicle. Potentially then they have to be allowed to park it in your community. But again, it's going to depend on your documents, when they were written, if you have Kaufman language. Perhaps there's an argument that, again, the statutory change isn't going to apply to you for various reasons. So lots of factors, and you bring up a very good point. That's potentially an issue. You may have to allow it when you wouldn't have had to before. So, my gosh, there's so much in here, guys. Are bids from competing vendors considered a contract? No, I mean, the bids don't have to be posted or whatever it is till the bidding process is closed. Because like you said, would that break the privacy issue between competing bidders? You don't post them until you have sort of all your bids. Let's see. My goodness, there's so much.
Julio and others asking about the slides. If you forgot to download the slides and you already closed your window after the evaluation. For those who attended in full, I will be emailing over the next day or so everybody a certificate to the email address you used when you registered for today's class. When we send out that certificate, I'll also have the link once again for the slides as well as everybody's contact information. So if you missed it the first time, you'll have it the second time. So good to go.
Someone asked a question about if someone's in collections for a past due balance, can they still vote? This is in a condo. So again, we talked about it a little bit. The statute does address suspending voting rights and then also voting rights being suspended by virtue of delinquency. You have to look at, again, the change is basically if you're going to do that, it's a 90-day notice. So a couple of different things to look at, and you have to do it properly. So talk to your attorneys and make sure, see if that's something you're able to do. All right. I know there's just a lot of this that is.
Can more than one owner accompany somebody for official records verification? Like, for instance, let's say I make the request, but I want 2 other owners in my association to go with me. Is that allowed?
Well, it used to be in the world of condos, it was the owner or their representative. They changed it to and. Now, I don't know about having multiple representatives with you.
Yeah.
It really, I mean, again, as a practical matter, that's not great because, sometimes these management offices or whatever it is are very small. You're not going to bring a whole
Right.
team of people. But
Right.
I would say you get to at least bring one.
Which makes sense, because if you are guided to the website to look for stuff,
That's
who's
the
to
other
say
thing.
there's not 27 people in the room with you?
Right.
So some of these things just don't make sense.
I know. Right. And they didn't sort of think it all through.
Yeah.
All right. Oh, I'm a CAM, but I joined the HOA board. Do I still need to do the director education? I think you do. I don't think your CAM credits are going to translate.
Actually, I don't have the ESQ after my name, but I have the bat phone line to somebody at the DBPR.
There you go.
And I asked that question. So yeah, even if you're a manager, but you're on your board, you still have to take the certification class. And the caveat there is, I think anyway, a board cert class is approved for board member certification by a different office than the CAM classes are approved for CAM credit. So
Right.
I think that's why you have that.
Somebody said that as of just today, the Supreme Court allowed the government to enforce the CTA. So I'll have to double check if that really changed today. I will tell you though, again, so check Jeff's article. The other caveat to that for us was most of the counties in Florida actually had a little bit of an extension anyway, because they were giving us an extension after the hurricanes. That you had 6 months on top of that anyway. So the requirement was then pushed back to, I guess, June 30th or July 1st, however they phrased it, for most of the counties in Florida. So even if it's back on, so to speak, you probably still have some time. But again, we're trying to stay on top of it. If a new thing came out today, I didn't get the alert, so I'm sorry. Thank you guys, by the way. People said thank you. I appreciate that. All right. I think we gotta.
Yeah, otherwise it'll never end otherwise.
I'm losing my voice.
It'll never end. The important thing is we got the required material covered. We're going to get people their credits. Emily, before I did make a promise, I'm going to hang out a little while longer and go over the evaluation process more slowly for everybody and answer any technical questions. But before I do that, parting words, please. How can people, I know your email address is on the screen, but any parting words and how you prefer people reach you?
No, emails are great, guys. That's the easiest probably. Oh, someone just sent me an email that says CTA is back on again. So again, this is like hot off the presses. All right. Send me an email, egannon@kbrlegal.com, or check our website and you can contact all of us through there. Thank you guys so much. Thank you, Ace. Thank you, Lisa. That's it.
We'll see you next time. And folks,
All
Emily,
right.
I'll talk with you soon. Thanks for
All right.
stepping
Bye,
in today. I
guys.
know some of you might have expected Lisa today, and Emily
I was
filled
going to
in
say,
last
it
minute.
was supposed to be a Lisa squared kind of day. And thank you guys for, letting me do the presentation instead. Lisa, I think, was under the weather, so just better, even though I'm starting to lose my voice here too. So, all right, guys.
Go get some hot tea. I'll talk with you
Everyone have a
later.
good day.